Originally all British law was written in Latin, therefore a quick read of any translation of the Magna Carta will swiftly reveal two things. The first is that is pretty readable, not backward and convoluted like a Shakespeare play. While there may be a few archaic words you may need to look up to ascertain their true sense, but it's still pretty readable, and there are no words that Shakespeare used. Secondly, there's also no letter U. The letter V was used, and notice the letter W, which is double VS pushed together but sounds W. This is an extremely important fact to remember, because when courts or legal documents refer to you, they are in fact granting you surety in the matter. For example, if you look at a warrant or a ticket from a policy enforcement officer, it will have a name and it will then refer to that name as you from then on. Joinder. For example, John Q. Public, you have been charged with, insert bullshit offense here. You equals surety. If you're ever at, not in, there is a difference, a courtroom and do not wish to have the benefit of surety, one has but to object to being addressed as you. There are many ways to do this. I might say, in response to being addressed as you, if I have led the court to believe that I am surety in this matter, then that would be a mistake. Please forgive me. Fun fact, a court must always grant forgiveness when asked in / or requested. Others, like myself, are a lot more succinct. For example, I might respond, fuck you. You're a you, I'm a me. By what authority do you address me as a you? The UCC is, in fact, the proof. Section 1, subsection 308, of the Uniform Commercial Code covers reservation of rights. This is a well-known fact, and this is how you use it. On entering the court, you aggressively make the first motion, that being, the reservation of your rights. But since you're the only one in the courtroom with actual standing, you can be a total dick about it. You don't reserve your rights, you reserve all rights. Not just yours, everyone's. You remove everyone else's rights and give them to yourself. Why? Because fuck off, that's why. You're the only one with standing. If you hold the power, wield it, don't be such a pussy. If you're entitled to all rights, claim them. This is how you do it. When the justice starts speaking, interrupt them. Say, point of order. They will immediately be silent. At that point, state I believe I am the only party with standing, so barring objection from the court, I wish to reserve all rights now, and henceforth. Are there any objections from the court? As the court has no standing to respond, simply speak to the record as such, let the record show that I have reserved all rights, and the court has not objected. At this point if they say anything to you, you simply say, objection. The record shows that I have reserved all rights, and I have not granted you leave to speak. Why are you speaking? Do the same when opposing counsel attempts to speak. You will then be posed the question, how do you wish to proceed in this matter? For that is the one question a slave has the right to ask. What is their master's wish? Recall the levels of the caste system and how they give instructions. Nobility, kings and queens, express their wishes. Admiralty issues instructions by requesting, addressing their subordinates as MR. Generals give orders. The fact that if you have all the rights, and everybody else has none, you are clearly the king. So you are going to have to learn to give instruction by expressing your wishes. This is why they are asking how you wish to proceed. Courts grant and test your sovereignty all the time. You simply have to listen to the words they are using. At this time you may respond, I wish the case to be dismissed. If they say anything else besides I agree, case dismissed, you exercise your authority by questioning. Master's question, slave's answer. For instance, if a justice said anything except I agree. Case dismissed, you question why they are even speaking. I'm sure you'll recall Mr. Insert Justice is named here, that at the beginning of these proceedings I explicitly reserved all rights, including yours. Have I not made my wishes clear? Always remember to respond in the form of a question. A question serves the dual purpose of establishing your authority, and negating the possibility of understanding, because if you understand, you accept surety. As stated before, the most powerful of these questions is, who are you? Understanding cannot be presumed until that question is answered. Above all, questioning deflects surety. Notice of mistake. This is a useful, powerful document that also instantly removes surety. Have lots of copies to hand out to friends and opposing counsel. Hell, the court clerk loves these things too, make sure the court clerk has one as well. Just make sure you understand what the document says. Read it carefully and understand what the words mean, because you will be challenged. And remember, the notice by its very nature, presents several questions. Do not permit the proceedings to move forward without these questions being answered. Notice of mistake. In the matter of surety for the legal name, I believe that there has been a mistake as the sole beneficiary has been incorrectly identified as the accused. If I, and / or persons and / or friends of the court and / or such other parties acting in my interests, have led the court to believe by responding to you and / or John Q. Public and / or such other identification this court has addressed me as, that I am the party with surety in this matter, then that would be a mistake and please forgive me. As I have no knowledge of who you and or John Q. Public and / or such other identification this court has addressed this man as, I respectfully ask, by what authority the court addressed this man as such? As the surety bond, birth certificate, has been deposited into the court, what evidence does the court have that I, as the sole beneficiary of the trust, have any surety in this matter? as the government is the sole signatory party on the surety bond, birth certificate, with sole and full surety as trustee for the legal name. What evidence does the court have that I am a trustee for the legal name? What evidence does the court have that I am a trustee and have any surety with respect to the legal name? What evidence does the court have that I am an officer, an agent, a trustee, or an employee of the Crown? What evidence does the court have of any warrant of agency for the principal? What evidence does the court have that there has been any meeting of the minds, any proper notice given, any considerable consideration offered, or that I have any intent to contract in this matter? As such, I am returning your offer, declined, for immediate discharge and closure. Authorized by... If you truly understand what this document says and/or does, this is one of the most powerful documents you can wield in court. If you have the Dunning-Kruger effect, you will likely go to jail. Used properly, the notice of mistake will always remove any real or implied surety the court believes you may have. You will notice the court always refers to belief. When I say belief is evil, it is not just a disparaging remark against adults with imaginary friends, which they totally deserve. It is yet another example of why this statement is profoundly true. All belief is evil. You are taught from childhood to respect belief, and are constantly reinforced with the really dumb freedom that it is your right to believe what you want. If I had the authority and/or power to remove just one right from humanity, and no more, the right to believe would be the one that I would eradicate. In all my years of studying, and being part of the nobility, the curtailing of this one right would exponentially increase quality of life for all humanity. I calculate it would take 2 generations for it to stick. Belief is the end of questioning. Belief is intellectual bankruptcy, and is the exact opposite of knowledge. You will never question if you believe. Let's leap back to the 1500s to Shakespeare. This is where the concept of addressing somebody as you indicated the assignment of surety. No writings before this contained any such logistic mechanisms. Don't believe me, go look for yourself. Go look at the Magna Carta yourself, and ask yourself why there's no you before Shakespeare. And ask yourself why the Magna Carta, in all its current published forms, no longer has to do right by Alexander. In any courtroom proceeding in the Western world, surety is presumed, and it must be deflected from you. As the justice is not a person under the law, the only party that can accept surety is the party making the claim. There may be certain readers who will demand proof of this, and so I direct you to the rules of civil procedure, wherever you are, to look up security for costs. Let's zoom back to the present, so we can get as far away from belief as possible, where the word you is part of the English language, as are the titles, Mr., Miss, and Mrs. All of these titles and means of addressing you, are in fact, assigning and/or presuming surety, yes, on you. The easiest mnemonic exercise you can do to make deflecting these titles second nature is to replace the titles Mr., Miss, or Mrs. with the word, bitch, in your head, and to respond as if they had addressed you as bitch, because being addressed as Mr., Miss, or Mrs. is doing exactly that. As for the word you, think of that as a tennis ball which must be served back. Assert your authority by questioning whenever they address you as you, are you addressing me? If they're stupid enough to say yes, or even to imply the affirmative, demand proof, by what authority do you address me as a party of surety? Or something along those lines. Your only objective is to serve the you back to them.